Morning. Your mic is muted still. There you go.
Good morning, Your Honors.
Hi, good morning. We're waiting for the state. Siegel, I think.
Siegel has disappeared from our screen.
Well, that's a common trick.
We're trying to get him back now. There he is.
There you go. All right.
Thank you.
All right, welcome. All right, Mr. DeRoches, you ready to go?
Yes, Your Honor.
Let's begin.
May it please the court, my name is Christopher DeRushy, and I represent Mr. Damon Ford, who is the appellant in this case, and I would like to reserve 5 minutes for rebuttal.
Got it.
This case started out as a first-degree murder case. The jury came back with a verdict of manslaughter, which I think is actually quite important when we actually consider the couple of issues that we're going to talk about today, which revolves around some comments that the state made during opening and closing. The first comment that the state made in opening was, there's no justification for what Damon Ford did. You may hear some testimony today from the defense, and you may hear something presented that says it was justified. But ladies and gentlemen, when you look at the video, objection! And defense counsel objected and moved for a mistrial because he claimed that it created a burden for Mr. Ford to go forward and improperly shifted.
Let me just cut to the chase. Did the defense ask for a curative and provide the curative and or consent to the curative?
They wanted a mistrial.
I know, but let's go past that question.
They then offered a concept for a curative for the opening. The judge then admittedly gave a variation on that and said...
Did they object after the variation was given, or did it say that's fine?
They didn't really say either.
Well, you can't have your cake and eat it too. You either object or you don't. If you don't object, then that's implicit consent. So you have to make an argument based upon implicit consent to get us to rule in your favor. Do you have an argument?
Well, my position on that is that when the trial court listens to both sides and says, here's what I'm going to do, they just did it. And at that point, if you start objecting again, I think you're just being annoying to the trial court at that point.
That's what they want you to think. I got you. Okay.
I mean, if seriously, at that point, you're just basically being annoying. They've made their decision. They want you to move on. That's what they want.
Well, is your argument it's fundamental error?
I don't really believe, in a sense, that it is fundamental. However, also when you look at what happened at closing.
Well, wait. Look, before you go on to the comments made in closing, let me cut to a different chase.
Okay.
Isn't what the prosecutor stated may happen exactly what actually happened at trial? I mean, didn't the jury hear some testimony and be presented testimony that it was justified? I mean, isn't that exactly what happened?
Well, eventually, I believe Mr. Ford did get up on the stand and talk about certain things, and I think he did try to justify what he did. But the difficulty is that when you see what the state did at the opening and you see what they did at the closing, and I think what they did was that they were subtly advertising to the jury, hey, the defense really has the burden of proof here. We don't. And they need to prove something to you, and we don't. And I think that's what was really going on. Because notice, even after the judge gave curative instructions in both situations, the state didn't try to correct their former statements. They just kept on going.
Well, with the first statement, what was there to correct? I mean, you may hear something. And in fact, that's what they heard. There's no discussion of proof or a burden in terms of the opening statement. Now, I agree that the comment and closing argument is a different thing altogether.
Yes.
But in terms
I'm sorry, you were saying something.
Just in terms of the opening statement, how, if we look at that in and of itself, what's the issue with that?
And I would say that the opening remark is probably less damaging, so to speak, than the one at closing. But if you look at both of them together, you can see what the state's doing. They're basically trying to convince the jury, hey, it's Mr. Ford's burden to prove his justification. It's not ours. And that's why particularly I brought up the opening and also the closing. But I also agree with you. The closing argument error is much worse on a scale of 1 to 10. It's by far the worst error of the bunch, because that's the one where the state actually said, they didn't prove beyond a reasonable what? And
Mr. DeRocher,
yes.
Let me ask, can you hear me? Let me ask you a question. On the curative that was given, what is wrong with the curative? Because it tells the jury whose duty it is to present the evidence, and it also states that the duty is not on the defendant to prove his innocence. And so I don't really see anything necessarily different from what the offered curative from the defense counsel was, other than, you know, they didn't get their sentence in that said the state has implied that the defendant has a duty to present evidence, and that implication is false. So what is wrong with the curative that was given?
I think one of the difficulties with the opening curative was that it didn't mention one key issue, was that it wasn't the defense's duty to go forward and present evidence.
Well, but it did. It said, I would remind you that the state has the sole duty to present evidence. Doesn't that take care of that issue?
Well, it does for us, because we're all sitting here and we're legally trained. You see, the reason why we have jury instructions is because those jurors, they don't know the law and they can't make reasonable inferences from the law. And that's why these two errors are particularly insidious, because we can look at this instruction and we go, oh, we can infer has the sole duty to present evidence. That means the defendant doesn't have to go forward on his defense.
Well,
jurors don't necessarily infer that.
It didn't just stop with sole duty. It said at no time is it the duty of the defendant to prove his innocence.
But how about his justification defense? Once again, jurors, we can't necessarily imply that they know the law and can make inferences from it. That's why we have all those jury instructions.
But don't we, isn't there a presumption that when they are instructed on the law by the court that they follow the instructions and that they abide by the instructions?
Absolutely. When they are instructed, the judge in this case didn't spell it out. That's the difficulty. In fact, look at the standard jury instructions and how they spell things out. They have to spell it out because we assume juries don't know the law and can't make reasonable inferences from the law. And so when a judge does a curative instruction, that he or she has to spell it out. And the difficulty is, especially with the, oh, sorry.
That's okay. To that end, okay, so following up on your argument then, was there anything during when the jury instructions, when the attorneys were going over the jury instructions with the court, that asked for any sort of clarification on that end in light of the objections that were made?
I'm not aware of that, no. But you also have to remember the closing argument one was done after jury instructions. So defense counsel didn't have a chance to be clairvoyant about that one. And I believe that one was far more damaging.
So let me ask you then the same question. The curative that was given on the second one, how does that not correct any error if there was error there?
Well, because a juror could simply look at that and go, oh, the state of Florida bears the sole burden of proving their case. Yeah, and the defendant bears the sole burden of proving his defense and bears the sole burden of going forward with the justification. Yep, that's how I infer it. You got to spell it out. He asked for defense counsel in that specific instance asked for two things. that he did not have a burden of proof and did not have to rebut anything beyond a reasonable doubt. And the judge just gave this one thing, state of Florida has to prove its case beyond a reasonable doubt. Well, what standard does the defense have to prove their case to?
Let's assume, I just have a fast question. Let's assume everything you say is correct, that this was not a perfect curative instruction. Do you have a case that you want to cite that says, therefore, he gets a new trial? Am I on mute? Or are you thinking?
Well, I was trying to refer back to my brief. I don't try to repeat things in my initial brief.
Well, I would like a case on point, because I don't think there's a case that says what you're implying. And if you can't find it, it's okay. I don't want to cut into your time too much.
Yeah. I believe it would be, the purpose of a curative instruction is to cure things. If this curative instruction isn't really curing the problem, it's not a curative instruction, and we still have the same problem as before. I think it's as simple as that.
Well, Mr. Commissioner, don't we have to find that the trial court abused its discretion in denying each of the motions for mistrial? And so, in other words, we have to find that no reasonable trial court would have done what the trial court did here. Is that right?
Well, he denied the motion for mistrial, and he tried to give a curative instruction, but the curative instruction was bad. And that's where we wind up with the problem. Generally speaking, you give a bad curative instruction, you still have the problem with the mistrial element. And in this case, essentially, you still have the issue that the jury's left thinking, the defense counsel had to prove beyond a reasonable doubt something. And particularly this weird comment that they made.
I understand that part of your argument, but could you answer my question as far as the standard here, that we have to find that the trial court abused its discretion?
Well, I think if the trial court chose to give a bad instruction in lieu of denying a mistrial, that was an abuse of discretion. I think the difficulty really isn't whether or not the judge denied the mistrial. It's whether or not they gave a good curative instruction. A bad curative instruction, my position is, that's harmful error. What if he just said, well, gee whiz, guys, you should do this because he's a Presbyterian. That's a terrible curative instruction, okay? But
and you would have to object at that point. Obviously something that obvious, that might be different, but obviously it's different. But if the court says, I'm going to deny the mistrial, I'm going to give a curative instruction, and you don't say, Your Honor, I don't think the curative instruction that you just gave is going to cut it. Can you elaborate for the jury? So that would give the trial court a chance. But the trial court gives the instruction and the trial continues, and everybody assumes that it's been taken care of. And so your point, well, I don't want to make the judge angry, is fine as far as it goes, but there is still an obligation that if you don't think that's going to cure the prejudice, to bring it to the trial court's attention so it can cure the prejudice.
And I understand the argument. I understand what you're saying, but it also kind of comes back to how many times do we have to tell the judge he's wrong? Especially after in a situation like this, where the parties have actually sat there and discussed the possible curative instruction before the judge actually issues it.
Well, Mr. Director, okay, so if that is your argument, then can you show us in the record where at any point during this discussion that the counsel for the defendant here told the judge that they were wrong and that they were somehow annoying the judge to that point, because I just don't, I understand what your argument is. Your argument is one in futility and that the judge has already ruled, but I don't even see one where there was a request that the court either sustain or overrule the objection, because I don't think the objection was ruled upon other than implicit that the court gave the curative. But where here is counsel, any record that counsel is annoying the trial judge at this point, or that they've objected to anything the court has said?
Well, I would hate to think that the standard is we have to keep objecting until we get yelled at by a judge.
It's your argument, but this is the argument that you're making, that they were somehow annoying the court to no end, and therefore it would have been an exercise in futility to further object when the time came for the curative. Because, I mean, as Judge Rothstein-Yoakum has stated in her questioning of you, is the point here is to give the trial court an opportunity to correct. Perhaps the court did not realize that what the full extent, or omitted it unintentionally. And so you want to give the trial court the opportunity to know that, hey, judge, that's not what I had requested. And at that point in time, the discussion could have been had. But I don't see the discussion was had in either of the events here that are being complained about.
Not to interrupt, but you've got a little over 4 minutes left if you want to reserve it for rebuttal.
Yeah, I'll reserve that for rebuttal.
All right, you got it. Mr. Siegel, you're next.
Thank you. May it please the court, Dr. Siegel, on behalf of the state. We're dealing with a very narrow issue here. It's whether the curative instruction amounts to reversible error. And first off, there is no error in the opening statement, because the state used may provide justification. The defense might try to justify their actions. And we have a motion, the defense filed that a stand your ground motion. They actually stipulated to the firing and killing of our victim in this case. So justification was the only thing they have left available.
Well, to that point, though, the stand your ground motion was withdrawn, correct?
It was withdrawn.
I mean, I don't disagree with you that once they stipulate to the shooting, their options are limited. But there was some discussion beforehand when defense counsel, I think, specifically refused to indicate what defense may or may not be presented. And so the state, I'm not saying it wasn't a reasonable assumption, but isn't that sort of risky to make that assumption in that particular circumstance?
In that particular circumstance, when using the word may, I think that the state covered themselves for providing that risk in saying the opening statement, yes. So, I mean, dealing with the curative instruction, we basically have implicit compliance, implicit consent by the defense not objecting to the curative instruction given. After the curative instruction that was given, which wasn't necessary, the court didn't hear any other further objections. So there's no opportunity to address this particular issue by the trial court. And moving on to issue number 2, we have the same thing with the implicit consent, that the curative instruction was given and the defense did not do any further objections. The defense has a duty to object and raise this to the trial court if there's any problems with the instructions. And the instructions did address whether the state has to provide the burden. And we're talking about at least 4 times the judge instructed the jury that the sole burden is on the state to prove the charges. We have the optional reading, which the defense acquiesced to in the beginning, the burden of proof. We have the 2 instructions when the mistrial was made. And of course, we have the final instructions indicating that the state has the sole burden of proof to provide the elements.
You're talking about the jury instructions at the end?
Yes, Your Honor.
And the written jury instructions went back with the jury, correct?
That's correct. They were
So all
written
we
down.
have is the verbal clarification that the judge gave without objection and with implicit consent. But the written instructions covered the same area completely. Is that correct?
Absolutely, and as was mentioned before, the jury is presumed to know and follow the instructions. So we have.
And they didn't come back with any questions. There was no questions in this case.
No questions.
Okay, thank you.
And if there's no further questions from this panel,
okay,
we ask that you affirm the conviction and sentence.
Mr. DeRocha, you do have 4 minutes for rebuttal if you'd like.
Unless the court has any other specific questions, I have nothing further.
No, you covered it pretty good. Well, gentlemen, thank you both. You have a pleasant day.
All right. Thank you, Your Honor. May I be excused?
Yes, you are. Thank you very much. And we're going to move on to the next case. That's the Elizabeth Taylor case versus Stephen Suter.